Hello, LinkedIn. Thrilled to be here. Hi, Max. Hi, Chris. How are you guys doing
Hey,
today?
good, Colleen. How you doing?
Good, good. As folks hop on, I just want to say welcome to Tag Your It, Navigating Pixels and Privacy. My name is Colleen. I'm head of marketing at Ketch and thrilled to be moderating this event today. We're particularly excited about this topic here at Ketch. It comes up a lot in customer discussions. I know it comes up for Kelley Drye as well, who's joining us here today. So, really excited to dive in and just demystify a lot of the complexity surrounding these web tracking technologies with you all. If you're not familiar with Ketch, we're a data privacy software company. We help businesses and brands to simplify privacy compliance, and thrilled to be bringing you this event. So let's go ahead and dive in. Tag your it. That starts with Chris and Max. Thank you guys for joining me in this discussion today. So let's start with some intros. Chris, why don't you kick us off?
We're starting with the less smart guy for the intro here. I like that. Hey, everybody. It's good to be with all of you. My name is Chris Tarbell. I'm a special counsel here at Kelley Drye. I started at Kelley Drye maybe like 6 or 7 months ago. Before that, I was like 10 plus years as an in-house privacy lawyer. I handle all things privacy related for lots of different groups, including specifically in the marketing and advertising space where pixels are a hot topic and have been for a while. And I'm really excited to be here with Max and Colleen, and it's great to see all of you.
Thanks, Chris.
Yeah.
Max, over to you.
Hi, everyone. I'm Max Anderson. I'm one of the co-founders and head of product at Ketch. I've spent most of my career, ironically enough, in the ad tech space, so building software that leverages a lot of these tracking technologies to help customers make better business decisions and sell more product through all these clever techniques. And I got into data privacy after the last company I was working at got acquired by Salesforce. And yeah, now I'm really excited to share some of the inside knowledge I've had in building these systems with the privacy community.
Excellent. Thanks, Max. So we've got a packed 30 minutes here and hoping we can impart as much knowledge as we can to all from these experts today. We'll start out with origins of the pixel madness and privacy. Chris will take us through how this all started, then get into some fundamentals and education on digital data collection and what that means on a website today. We'll move into side effects of the challenging technical concepts on this bit. And then lastly, we'll wrap up with some practical advice for in-house teams navigating these risks. So let's not waste any time and dive right in. We're going to start with talking about what started all of this noise and content and legislation around pixels. So Chris, it seems like it all started with this Facebook pixel. So talk to us about how this happened here.
Yeah, sure. So, yes, there has been a tidal wave of lawsuits involving pixels and, as Max will explain, other technologies that people have labeled pixels but are in fact tags or other kinds of things. And really, the plaintiffs bar and regulators too have looked for ways to focus in the advertising and marketing space, and pixels is one of the areas they've chosen. And at least on the plaintiffs bar side, that's in part because of the ability to leverage the facts involving deployment of pixels to advance legal theories that provide everything that all plaintiffs lawyers are looking for, which is high value potential settlements and huge leverage for against big companies. And there are two sort of main groups of cases that really spurred this, although the theories that were asserted and the types of people that are facing exposure have expanded way beyond these. But the origin story of these is the first group is a long held, tried and true litigation claim that plaintiffs' lawyers have liked to use under what's called the Video Privacy Protection Act. And without getting too far into the details, the VPPA was a 30-year-old statute that was designed to protect against disclosures involving information that identifies a person and specific video data that they may have requested or obtained. And it was born out of a specific case relating to a Supreme Court nominee, Robert Bork, and a newspaper reporter going down to his local video store and trying to identify what he's rented. And it was nothing interesting. It was like mostly about like national parks and weird stuff like that. But as you can imagine, Congress got really excited about this topic and passed the VPPA because other people might have renting content that was less innocuous. And the VPPA's had a sort of long history, maybe about 2016, 17, a huge wave of cases were filed involving disclosures to Facebook, but not involving the pixel. But I would say over the last 2 years, hundreds of cases have been filed alleging violations of the VPPA. And the theory is pretty straightforward, right? You deploy the Facebook pixel on a page that has video content. And specifically, that includes things like where your video player is embedded, or if you're trafficking video data as part of a watch page, then that necessarily means that you will be sharing information that identifies a person to Facebook, because the entire purpose of the pixel is to be able to share data with Facebook to then subsequently find those users. And then also, in many cases on the web pages, there's a URL that identifies clear text information of the content that somebody is watching. And people are doing that because of SEO and those kinds of reasons. And so you put those two pieces together and you have a VPPA claim. The other category of groups of cases that have been filed involve the wiretapping statute. And it was all started here in California. People looked to a long on the books statute involving true criminal activity where people were intercepting communications, and much like the VPPA, have grafted that onto the current digital market. And the theory, again, is pretty simple, is look, by inclusion of pixels on your page, you are permitting a third party, in this case Meta, to intercept the contents of your communication that was intended to be between just the user and the website. And that has been around for a while. Thousands of these cases have been filed, many of them settle, some of them have gone to court and in fact are now at the appellate level. But it's a basic concept that you are allowing Facebook to intercept the contents of your communications through the deployment of the Facebook pixel. And so that's really the sort of major sort of background on how these cases started.
Thank you, Chris. That's super helpful.
Yeah, no problem.
So as we think about this, right, the pixel has been getting so much attention, but it's really, when we think about digital trackers and technologies, it's much bigger than a pixel, right? This is just one sample. So Max, give us a little bit of an education on this. What are we talking about?
Yeah, so first and foremost, I'm hoping that there's interest from this community in going a little bit deeper in a different session. It's a tall order to try to summarize everything in just a few bullet points here. But I think the number one takeaway here is pixels are not the only thing that facilitate data collection. So on the left here, what you have, I think, are a good representation of the four most commonly used techniques or technologies that facilitate data collection. The first one is a tag. It's a JavaScript tag. It applies only to web, but I think this is the biggest and most important one, because what happens with JavaScript is once you put JavaScript on your website, the possibilities are endless, effectively. You should think of JavaScript tags as orchestrators or facilitators of literally anything on a website. Once you put that script tag on your page that's been provided by a third party or a SaaS provider that you use, the way that code has been written, it can facilitate all sorts of data collection. It can render things on your website. It can fundamentally alter the way that your website works. And so from a privacy perspective, it's important to appreciate that specifying and fully understanding the implications or what happens just by virtue of the JavaScript tag being there is actually quite difficult. You need to go a level or two deeper to actually fully uncover and understand that. So JavaScript tags are, the most important mechanism on web. I think the more commonly discussed in all this is pixels or beacons is another word that is frequently used to describe this. This is a much more constrained and confined data collection technique. It's actually what does the data collection by and large. And a pixel is basically a one by one. When you think about buying a TV, You obviously look at screen resolution and the pixels. A pixel is frequently, sometimes not always 1x1, but mostly a 1x1 invisible image. And all it does is make a server request. It says, hey, server, give me this image. And in doing that, just by virtue of the way the internet works, it can and does transmit data. And there are ways that happens. We'll cover it in a minute. But that pixel can only make that server request. There isn't any additional functionality that can be facilitated by virtue of having a pixel on your web page. SDK stands for Software Development Kit. Software development kits are by and large intended to help developers build software more effectively. So you can imagine if I wanted to build a chat app, for example, or like a social media app, but I didn't want to build the chat functionality from scratch, I might leverage an SDK delivered by a third party that kind of happy mealifies, if you will, the ability for me to deliver the chat functionality within my app without having to write it from scratch. In the context of data collection, the majority of third-party SaaS applications that facilitate data collection on mobile or non-web devices frequently do this through an SDK. And once that SDK is implemented by your developers, the developers have additional tools and ways to log or collect data within the context of that app. And then lastly, there are APIs. API is probably the most generic kind of device agnostic or technology agnostic way to collect data. It simply leverages HTTP. That's the way that we all experience the internet today, to, in a very fixed and prescriptive way, exchange information between two servers or applications. And so sometimes you'll see data collection happening on a mobile device via an API. You might have it on a smart toaster or some other technology, but APIs are intended to be generic in that exact way. So those are the four ways that predominantly data gets collected. I think the second really important consideration here is the way that these tools identify the individual, right? It's about personal data. So how do they identify the individual? Frequently people say the word cookie and that kind of ends the conversation. It's important to note that cookies are just a storage vessel or a mechanism in a browser. I can say hello world in a cookie and it doesn't necessarily identify the individual. So usually, developers and various technologies will create a random identifier and store it in a cookie, but not always. It might be local storage or another storage location inside the browser. So those one category of identifiers, browser IDs, as I call them, this isn't necessarily a perfect taxonomy, but it's meant to give you some kind of segmentation of the different ways identifiers happen. Second is platform IDs. Those are generated by the the manufacturer. So Apple provides one, IDFA and IDFV. Android, Roku devices also provide those, and those are the devices that are frequently used in those contexts to identify an individual. And then companies will also set their own IDs. When you sign up for a loyalty program, that might be an identifier used to track that individual. And then lastly, all of us come with government issued IDs, phone numbers, email addresses, physical world addresses. Those are identifiers that are also used. And so any combination of the left and the right can be leveraged to deliver data collection against an individual.
Thanks, Max. And I want to add, we have a comment here from Ramona saying she's not afraid to go deep. Let's get into it. So don't hold back. Okay.
Okay. Well, if you open that gate, we might be here all day. So I'll take that as a +1 for a follow-up, and we'll definitely go deeper in the subsequent session.
I love it. All right. So Facebook Pixel, how does this one actually work?
This is a pretty standard kind of turnkey implementation that most companies actually use. The first thing to note is it's not actually a pixel. It's a JavaScript tag. And so, again, these terms get used and abused both by non-practitioners and practitioners alike. Developers will say, yeah, it's an SDK, but maybe it's not. That's not the high order bit, but it is interesting and noteworthy that it's a JavaScript tag. And so you put the JavaScript tag on your page. And as I mentioned before, once it's on the page, any number of things can happen. And so the JavaScript tag, by virtue of being on page, there are some standard data collection that happens according to Facebook. I tried not to take liberties, and I took it directly from the documentation. So by default, the actual pixel will track the URLs, the domains, and the device, where device might be the unique browser ID or the IDFA, IDFV that your visitors are using. So it actually uses a beacon or a pixel to collect the data, but it's orchestrated by a JavaScript tag. And those are the standard events that Facebook will collect, and they're important, and we'll come to why in just a moment. But then there's literally a boundless set of information that can be collected or configured to be collected by either developers or people using some of the UI-based tools that Facebook provides to collect additional information. And it literally is unconstrained in a way in terms of what's possible. So it really, again, depends on what's been configured by the company and by the developers or the tool operators. So if you go to the next slide here, we'll talk a little bit about what is possible. And so I won't, go too crazy here, but our friends at Civic Data have put together a really nice taxonomy that you're looking at on the right that I thought we would just borrow to expedite the conversation. But the fundamental truth is anything is possible. What can be passed to Facebook can be the way your mouse moves on the screen, what you fill out in a form, the URL information that is provided by virtue of the way the internet works. So device information, IP address, which is proxy to location, precise geolocation, what your language preferences are. There is what website you came from and where did you go thereafter. How long did you stay? I'll stop there, but it's really, really quite boundless what can be collected. And so any of these things that you see on the right can be configured by your tool operators, to say that generically, and that's why it's important to speak to them. On the left,
Max,
yeah.
One of the things I just wanted to say that I think is so important about what you're saying is, one of the common things I hear on the legal side from folks is, well, my business team is telling me that we're not collecting watch data or we're not collecting sensitive data through use of these tools. And so I think they're understanding how they function and including things, as you mentioned, it maybe they haven't customized an event for that, but by virtue of the way the tools work and deploy, that may be not the factually accurate to say you're not collecting them. And I think also people conflate use and collection. So I'll hear, oh, well, I don't know, I'm not doing anything with watch data. And again, that may be true, but that's not the way the technology works and not is sort of what forms the basis of these claims. So I think the background you're giving is just so essential and like a real material part of lots of discussions I've had with companies about their potential exposure and those kinds of things to get through use of these different tools.
It's so true, and it's a perfect setup, actually. The reason that I put this inference example on the left is there is that difficult connection that has to be made, whether it's a technical practitioner or a privacy or legal practitioner hopping across to the other side of the discipline to make that connection. And so, Facebook in the prior slide says, yeah, we'll collect the URL that's visited. Now we're talking about VIPA, and you look at this example. I happen to be a Colorado Avalanche fan. Go Avs later today. But if you look at the URL that gets by default passed, I can infer by cbssports.com that this individual might be a sports enthusiast. And NHL, they're probably a hockey fan. And then you look on the far right, the Colorado Avalanche, maybe that's a favorite team or a team of interest. Imagine if that were a URL that lent itself or categorized the way that I watch, one of these streaming providers, and what then that could mean for VIPA compliance. So it's important to just kind of diagnose exactly how how this works and kind of broadcast it to the implications from a privacy perspective. And I think that's what makes this problem so hard to solve.
Exactly. Totally right.
Excellent. Thanks, Max. Well, putting all that technical knowledge and education in perspective, I think the challenge and what we've all talked about is that one of the things this technical complexity has led to is major confusion in the industry, right? Just lack of practitioner and regulator understanding. So as you both kind of teased, I want to dive further into kind of some of those related tangential questions. So Chris, starting with that bit about the third party, right? If I'm a business side stakeholder, right, I'm using Facebook, I'm using HubSpot to using the tools to facilitate my own objectives. So it's a little unclear as to why I would consider them a third party, right? If I understand what you're saying before, I'm only breaking the law when I'm translating those informational bits to a third party. And while they are a third party, they also seem to just be a processor for me. So can you unpack that a little bit?
Yeah, no, super good question, Colleen. And again, I think to Max's point earlier, sort of bridging the technical realities compared to how these have been interpreted under various legal theories that's where all the action is, right? So, without getting too deep into the details of how the various state laws define what is a third party, I think it's essential to understand, often Facebook, their terms are saying, hey, we're going to use this data for purposes beyond just providing services for you, right? They're explicit about that. And it's innocuous things that most folks don't believe really make them not a service provider. Like, we're going to improve our products and services. We may de-identify that and look at that data across our entire network to determine, like, operational efficiency and was there a security incident and those kinds of things. And while some of those may still be service provider, type activities, it's not always the case that can firmly fall into a service provider under the law, right? So the technical way these things reality work alongside the sort of legal interpretation of what really constitutes a third party or not makes the universe of people where there's potential exposure much broader than I think the average business side stakeholder would think of. A perfect example is there's been a sort of very, very recent uptick in wiretapping statutes against payment processors. So you go to your website, it's an e-commerce site, you are most likely encountering a third party that's doing the payment processing on behalf of that publisher. Almost everybody that I talk to, my mom included, thinking about Mom's Day, would say, oh, well, of course, that's a service provider just to the publisher, right? But there have been new wiretapping cases saying, hey, you are the payment processor is intercepting my communication by providing metrics like fraud alerts or using like a pub submodel to say this is an invalid card for client X, so we're going to give the benefit of that to client Y. And so again, the population that plaintiffs' lawyers are using to describe as third party is immense. And again, coupled with the way these technical solutions often work, it's not the case that you can sort of use a common nomenclature and say, oh, well, they're just doing stuff for us, that things. The details, as Max mentioned, really matter.
Right, right. And just speaking of this universe being so big, it feels like, back to what you've both been saying, it's not necessarily a Facebook thing at all. It's an everybody thing, right? If I'm using Amplitude, if I'm using any third-party SaaS app to help me operationalize my strategy, it seems like I'm at risk of transferring my data to a third party. Is that right?
Yeah, I mean, look, I don't want to alarm everybody and go full sky is falling. There are some ways to categorize these things in terms of a risk spectrum, right? I think Facebook gets the most attention, and like tools, because again, as Max mentioned, these are not indicative of just Facebook. All sorts of social media tools operate in the exact same way. You picked it, TikTok, Snapchat, they all have similar tooling in the universe, right? So, but advertising is one that gets a lot of attention because it's easy. There isn't even really a great argument that this is truly not a third party. Now, there might be some ways that you can implement it to help you do that, but there's a hierarchy to the way the risk is spectrum. But in terms of the sort of appealability of the legal theory, you're right. It's hard to constrain to say, these are all the things that it doesn't apply to, and these are things are, right? The theory of, hey, you deployed a tag or, a pixel on your site, and it necessarily communicates this data. All plaintiffs have to do is plead on information and belief, and then they're going to survive a motion to dismiss. And then companies have to make real world decisions to say, well, am I going to settle this for 50x, or am I going to potentially face, billions of dollars of exposure? And remember, the VPPA, the reason it's so attractive is it's $2,500 per unlawful disclosure. So you take the average number of video views that you might get on a site and quickly multiply that by $2,500. That's pretty quickly bet the company litigation.
Wow. Yeah, makes sense. So then last point here is, Chris, just back to repeating a bit, you made that point about the way the data is collected being important, right? That has an impact on whether we consider one of the apps to be third party or not. So, how do we think about pixel versus conversion API? Like, how does this hold up in the context
Sure.
of that technical scrutiny?
Great point. And my good friend Max will help sort of feed this in if I get this stuff wrong. But if you think about it, the pixel or JavaScript tag, if you're being technically accurate, is a client-side technology tool, right? On page load, subject to you not having a consent management platform, but it's on the client browser, right? So it fires automatically. That poses real easily sort of conceivable arguments for plaintiffs lawyers to say this was an interception, right? It's hard to intercede between the get request that comes out of the pixel to the entity that isn't necessarily a part of the way the thing functions, right? The difference with an API is it might be the way, depending on how you play it, less real time. It's not tied to a client event. It's a business tool that's fired sort of after, or you can expose data after the fact. And there's an easier way for businesses to curate the data that might be exposed in an API compared to a pixel. So for example, in the video context, if you think about it, whereas it's necessarily the case that I have to expose the URL when the pixel loads or the JavaScript tag fires, the same doesn't occur on the API, so I can still achieve my business objectives because I can curate better what data is shared through the back end API compared to the front end. So I might just say, hey, here's a bunch of IDs. This is segment B. Tell me whether they received an ad on Facebook or not, right? Which is the primary purpose of measuring conversion. Facebook doesn't need to know how the segment was constituted before you share that data via the API. You don't have to tell them that it came from the page for the Colorado Avalanche game tonight. They just need to know that they're measuring this group of IDs. So again, I think Max's summary is so helpful because that's really where you start thinking about remediation. Like, how do I keep my business doing the things that matter to them while mitigating my legal risk?
I think one point I like what you said, Chris, and if you can't beat them, join them. The perception of interception seems to be the critical point here, where the technical nuance aside about, well, yeah, many of these things that happen by virtue of the JavaScript tag being on page are explicitly configured to be collected. Sure. If it's seen as there's more separation in space between these things that happen client side through tags and beacons and a conversion API, by all means, avail yourself of that space because it seems to help you from a legal perspective. And by and large, there isn't this profound technical impact.
And just like that's right. Just like you and I have talked about before, like even again, if you're like sort of chuckling to yourself because you're like from a technical reality, like these distinctions like may not be as immense as they're made out to be. If there's a legal benefit, understanding how to sort of explain this in settlement negotiations, in FAQs, in various discussions you have with plaintiffs lawyers or your own business team, this makes a big difference.
Mm-hmm. Thanks, Chris. I think that leads us right into just wrapping up with this practical advice here. I loved what you said as we were prepping for this discussion, just about the importance of credibility for an in-house lawyer and how understanding these concepts really creates that. Can you expand on that?
Yeah, and again, I'm sure everybody on the LinkedIn Live here has had this experience or can agree with it. Like, I definitely feel that as an in-house lawyer, your credibility is the currency that you use to get stuff done. And I think if you're able to talk, competently and credibly about the way these things function, and even concede that, hey, I understand this may not be the technical reality, but let me tell you how that translates to the law. It makes such a difference when you're talking with your business partners to be able to help them understand why you're asking what they do. They're already strapped. Their roadmap is full. The next 15 sprints are already accounted for. And if you can't help them understand sort of the benefit in the context of making the changes you're asking, it's really hard for everybody to win-win. And so I understand it can sometimes be daunting, these tools, but I do really think folks like Max and stuff, there is a real way to understand them at a meaningful level that you can have credibility with your business teams.
Thanks, Chris.
Yeah.
Next, can you take us through a couple of the other high points, maybe about the data we're sending and the possibility of leveraging something like a CMP?
Yeah, sure. Just to highlight some of these bullets, right? I mean, there are some things that are beyond your control, either because of the nature of the technology or where it and how it needs to be deployed to function. So understanding what the default data, you can do that, and you can help address things like maybe you don't have the full content name in your URL when you're doing to address VPPA mitigation. But at the same time, then you also need to function on, well, what is the teams, what are they specifically sending by way of customized event? And so those things really matter. Again, there are commonly, commercially available tools in order to see what's in the network traffic. And again, I also think there are many big privacy software companies, just like Ketch, who can really help you understand, hey, when this gets deployed, this is how this functions on your site. These are things that they can be understood, and again, they're going to make a big difference until you figure out, like, well, what is my risk mitigation strategy? And so I think there are lots of things that you can do. I think coming back to the top, just understanding the details make a big difference. When I speak to Max about different things in my own practice, I mean, we're going to have a meaningful conversation, and that depends on us being able to really talk about the details, not just, hey, we have a pixel, but I don't know what it does. That's not going to help us collaborate on a way to help clients solve their problems. And so, again, I really think all of you can do this that are on thing. It's really something that I think would make a big difference.
Thanks, Chris. Max, can I ask you to pick this question up from the chat? Does the cookie banner help mitigate these issues, or should I consider something different?
At the risk of being a little bit cheeky here, I don't think a cookie banner helps you do much at all. I only say that because there is this, I think, profound misunderstanding of what the problem that needs to be solved is in the context of privacy. And disclosing cookies that are on your website is an interesting and important obligation, certainly under ePrivacy. But controlling the way data gets collected and doing it maybe by attribute, not just by Facebook, not Facebook. And actually going into that level of detail, I don't think is in the realm of what traditional cookie banners offer. But I do think consent management done thoroughly and at a level of depth that contemplates these issues, there's definitely software that can help solve this problem. But it doesn't obviate the need to have substantive conversations with your counterparts. And that's an important point Chris made, and you can't do one without the other.
Yeah, and I'll say also, just to add to what Max said, which I agree with wholeheartedly, is the banner is useful maybe for some problems, but not all. I think we've come to a point where people see cookie banners as a sort of absolve me of all risk. The issue is that that's not the way the law works. And so, for example, to give you an example, VPPA, you can't get a consent that is sufficient under the VPPA through a cookie banner. So if you think that your cookie banner is going to solve all your issues, it's hard to align that to the way the world works. It may help you mitigate your risk in terms of whether or not somebody would find you an attractive target, like a risk of claim analysis. But for VPPA issues, for like collection of sensitive data that is, the FTC has said repeatedly is a problem through the use of pixels, it's hard to find cookie banners, as Max said, sort of be a one-stop shop for absolving your risk for all of these things. I think it's a multi-part strategy. Maybe you use a cookie banner for some things, but I think, as Max mentioned, there are lots of other tools in the tool belt that I think would be as useful, if not more so.
Thanks, Chris. Thanks for the great questions, folks. Well, that takes us to just over 30 minutes. We knew it would be tough, so we had a feeling it might be need for a part 2. So if you like this content, if you want us to go deeper on anything else, we'd love to consider it. Please drop us a note in the chat, DM Ketch. We'd be happy to talk more or take your suggestions for what we should talk about next in our next LinkedIn Live. And then lastly, if you are interested in considering something like a CMP or upgrade to your cookie banner, we would, of course, love to talk with you at Ketch. The best way to get in touch with us is just schedule a demo on our site, ketch.com. And here we've got Max and Chris contact info as well. I know they'd be happy to continue the conversation on an individual level. So with that, I think we'll wrap up. Thank you, Chris. Thank you, Max, for joining us today, and hope to see you all soon.
Thanks, everyone.